Welcome to Bankruptcy Couch Counsel, a Hirschler-Fleischer video series on the legal and business issues and trends, keeping business owners and business creditors up at night. This is Steve Leach, and with me is David Swan. We are both bankruptcy lawyers in Hirschler's Northern Virginia office. This is the first of a four-part series on the many options available to troubled businesses under the Federal Bankruptcy Code. In this first episode, we're going to discuss the bleakest but still necessary part of the bankruptcy world, liquidation of a failed business under Chapter 7 of the Bankruptcy Code. If for any reason a company is no longer viable, it is time for the owners and management to at least consider using Chapter 7 to wrap up the company's business affairs and dispose of its assets. So David, help us dive into Chapter 7.
Thanks. As Steve mentioned, Chapter 7 of the Bankruptcy Code creates a framework for liquidation of a failed business. Liquidation under Chapter 7 comes with multiple pros and cons. I'll just discuss a few, mostly cons. First, at Chapter 7, trustee is appointed to take control of the business and its assets. Now, it might seem like a relief to hand over keys of a failed business to the trustee, but keep in mind that handing over the keys means handing over control of the business to an outsider of the business. So when a Chapter 7 case is filed, owners and managers no longer have a right to take any action for the company. Everything is controlled by the trustee and the bankruptcy court. Secondly, a Chapter 7 filing typically means that all business operations stop immediately and all employees are terminated. So for business, a Chapter 7 filing is like sticking a pin into the balloon, or it's like a corporate heart attack. Third, in many cases, the assets have no liquidation value, or the assets are subject to bank liens, which must be paid off before unsecured creditors get any of the net proceeds. This means that despite everyone's best efforts, creditors in most Chapter 7 cases either receive a small fraction of what they are owed or receive no distribution at all. It can really be a cruel world, Chapter 7. So Steve, what else should a business think about in deciding whether to file Chapter 7?
Thank you, David. You certainly offer an upbeat message. A Chapter 7 filing triggers what is known as the automatic stay. The automatic stay is like an instant court order that bars creditors from seizing a company's assets or filing or continuing collection lawsuits against the company. This means that a Chapter 7 filing gives the Chapter 7 trustee a chance to liquidate the company's assets in an orderly way, thereby maximizing the value of whatever is left. This benefits all creditors, and it even benefits owners who have guaranteed company debt, because the more creditors receive, the less owners will owe on any personal guarantee that they may have provided a creditor. This last point is important because Chapter 7 for a company does not protect the owner who has personally guaranteed company debt. The owner still has some exposure. One more point. Under Chapter 7, a trustee may have the power to sue the company owner or company creditors who have received certain debt repayments from the company prior to the bankruptcy filing. It is very important that an owner talk with the company's prospective bankruptcy attorneys about the possibility that a trustee may chase third parties, including the owner, for money when discussing whether and when a company should file for Chapter 7. With that, David, do you want to wrap things up for us?
Sure. If you have a question about Chapter 7 for businesses or any other bankruptcy question, please let us know. We're here to help. And please tune in for our future episodes on Chapter 11 reorganizations. Until next time, thank you for listening.